According to Bentham, every law, according to Bentham, the law is an imperative one because the law is issued by the sovereign authority as a command, and therefore these two are the characteristic features of imperative law. Because it has fixed authority, it has a fixed source, and therefore these are considered as imperative. Natural law मध्ये कसं आहे, the source is not very much clear, the source is abstract, and therefore that considered as an abstract theory of law. Natural law theory is abstract theory of law, whereas the imperative or the positivism, the positive theory says that the law has a definite source and the law has definite force and source. Okay, now according to Bentham, the law may be considered on the basis of 8 respects. These are the 8 points on the basis of which we can analyze the concept of law of any legal system. कशासाठी आहे हा? तर first, to check the law in a particular legal system. To check the law in any particular legal system, we have to find out what is the source. Means the law, by whom the law is issued. Whether it is issued by any sovereign authorities, that is a state, or whether it is issued by any religious structures or any supernatural power, that is without except human being. This is the source. Who is the source? Who has issued the law is very important, because this factor decides whether that law is a binding or not, whether that law has a particular enforceability or not, and therefore it is very much important to see the source of law. Next, subjects. Subjects means people किंवा प्रजा, people किंवा प्रजा. कोणाकरता हा लॉ लागू करण्यात आलेला आहे? टू whom the law is applicable. इथे काय दाखवला? By whom the law is made आणि for whom the law is made. कोणाकरता लागू केलाय? Who is the subject? Who is subject to follow the law, that is subjects. Then objects. Objects means for what purpose the law has been made. For what purpose the law has been made. What is the object? What the law wants to achieve or to secure. What the law wants to secure. Extent. That is the jurisdiction. To what place, to what territory this act is applicable. What is the extent? What is the scope? What is the ambit of the act? Then aspects. Aspects is a kind of technical one. Aspects means what are the aspects of law? Aspects means the construction, the body of language, in which aspect the law has been made. In which aspect means the object and aspects are closely related with each other. Aspects means what are the corners, what are the intricacies that the law want to fulfill, the law want to cover. Then force means the enforceability. Force means enforceability, the bindingness. What is the force of law? Whether the law is a binding or whether it is a persuasive or directory in nature. Then remedial appendage means the remedies which has been attached to the law. What are the remedies or reliefs that the act provides? And expression means the place for interpretation. Expression means the place for interpretation. That is the judicial scope, the judicial scrutiny of the act. That is the expression. Expression म्हणजे for example डायरेक्टरी आहे, मॅन्डेटरी आहे, मे शब्द आहे, मस्ट आहे, काय आहे. तर these are nothing but we can say these are the rules of interpretation. If you find that these are the 8 points which has been covered in mischief rule, in Hayden's case, that we should find out what is the object of law, what is the remedy of law, means these are the 8 points on the basis of which we can analyze any law. We can analyze any law or any legal concept which is provided under the law, and therefore according to Bentham, why he is considered as an imperative, why the Bentham is imperative, why the Bentham is practical jurist, because he tried to analyze the law in the light of certain scientific approaches, certain scientific methods. These are the research methodology which has been developed by Bentham in order to analyze, in order to investigate the concept of law and the concept of any legal system. Therefore, he says that these are the criteria, these are the respects, these are the points, these are the touchstones on the basis of which we have to analyze the law, and therefore he is regarded as an imperative jurist, or his theory is considered as imperative theory of law, which is very much practical.